lunch or at least a good break from the morning docket. Call the next case.
State of Tennessee versus Joseph Darnay Graves.
Good afternoon, Your Honors. Todd Ridley on behalf of Mr. Graves. If I could have 4 minutes for rebuttal?
Yes. Good to see you, Mr. Ridley.
And the court as well. Yes, I'll get started. Despite the size of the record in this case, that we have a very simple issue before the court with very limited facts that are, for the most part, I believe, undisputed. That issue concerns whether the state adequately proved that venue for over the offenses of the sale of methamphetamine and heroin was proper in Madison County. The problem with trying the case in Madison County, or these two offenses at least in Madison County, is that the alleged transaction by the state's own admission took place entirely in Gibson County.
So I saw that in your brief first. Yes. That was the proof, I think, what, at trial or during the, where did that come from?
That's from trial.
Okay, so when the trial court heard that in your motion for a new trial, that was not convincing at all? Or? So
the trial court's response to that argument was, I believe, incorrect. What the trial court found or held was that venue was appropriate in Madison County because the buyer, who later died in Madison County. So the trial court's reasoning was, well, these drugs made their way back to Madison County, therefore venue is appropriate here. And the problem with the trial court's reasoning is that that has never been the case, that the end destination of drugs is where a sale or a prosecution for the sale of those drugs can be had. So under the trial court's logic, someone could buy drugs in Mountain City and then, completely independent of the seller, drive to Memphis.
So the trial court's analysis was the continuing offense theory, correct? Or no?
I'm actually not sure that was what the trial court was saying, because the trial court was not saying that an element of the offense occurred in Madison County. He was just saying because the drugs made their way back there, that made venue appropriate. But I think Your Honor's question illustrates the problem with the trial court's logic, is that the trial court didn't even find that it's a continuing offense. It essentially just added an extra layer or an extra way for the state to prove venue that frankly does not exist. That does go to the question of, is this a continuing offense that could be prosecuted wherever an element happened? First off, I do not believe this is a continuing offense because the language of the statute does not support that. The language of the statute is about as simple as a criminal statute can be. It's just a defendant or a person cannot knowingly sell a drug. That's pretty much it. And that does not in any way indicate an ongoing course of conduct the way many other offenses do, the way embezzling does, or certain types of theft, or conspiracies is the primary one, where what the state is prosecuting is not just one discrete act that occurred in a single place. What the state is ultimately prosecuting is an ongoing course of conduct where they're going to need to put on evidence of things that happened in one county and then another county to make their whole case. The state could have proved the entirety of these two charges in Gibson County.
That was my next question. You concede that basically your remedy is remand for new trial. That's what you're asking this court to do.
Yes.
And you're conceding that the evidence is there in not Madison, but Gibson County?
Under the standard of review that this court considers the evidence, I will concede that the state presented enough evidence to establish venue in Gibson County. And so, because of that, the remedy that we're asking for is a reversal and then remand where the state can do whatever it wants to do as far as the prosecution goes. I think likely Gibson County is the only place this could be prosecuted, and that would just be up to the state and the two DA's offices to sort out how to handle it. But I suppose the larger point is that the state is free to do this on remand what they wind up doing is entirely up to them. That was a somewhat surprising result to me, but the Supreme Court in the Hutchinson case from not that long ago said that's the remedy. Even though it's considered under sufficiency, you would expect the remedy to be dismissal, and I certainly would prefer to be arguing for that remedy, but that's not what the Supreme Court said we can do, so
Okay.
I'm not asking for it. Now, what the state is able to accomplish on a remand is, again, I don't know. But the larger point is a drug prosecution is a simple case. There's a sale, there's a buyer, and there's an easy place to prosecute it, and it's where that sale and purchase happened.
Do we have any cases, Mr. Ridley, where we have a single count of a drug sale that was prosecuted in a county outside of where it took place? Any case law?
I cannot find any where that has
Okay.
happened, where there has been there are a lot of cases where there's a conspiracy to sell
Sure,
drugs,
sure.
where certainly those are prosecuted, in any county where the conspiracy happened. But as far as a isolated prosecution, at least in cases that I could find on Westlaw in Tennessee, I could not find a single one. Or not only could I not find one, I couldn't really even find a place where the state had attempted to do this, because most often there would be no reason to even try. This is a somewhat unusual case, I'll grant the state this, where there is, what they were attempting to do was to try a murder case because the victim ultimately died in Madison County. And to be fair to the state, I think what might have happened is there's this big component of trial they're focused on, and this part of, well, what actually happened and where did it happen might have gotten missed. I don't know exactly why that happened, but it did. And whether, regardless of the reasons, the problem is ultimately a constitutional one, and the Supreme Court has made clear that if the state doesn't prove venue, well, they at least get another chance if they want, but it is a problem big enough that it warrants tossing the conviction.
What
And-
about these boots at the mother's house? I saw that in the facts. I believe there was some police testimony that these boots could have been a drop-off point for the drugs. Did I misread that from the briefs?
I recall something about boots, but I don't think that would have any relationship to venue over this transaction. So I believe what the testimony regarding that would have been was what they recovered when they were at the victim's house. So they're called to the victim, I believe it's his mother's house in Jackson, where the police begin with we're trying to revive this person, and we're doing just kind of a general search of the area where they find a host of narcotics and other contraband that was not ultimately part of this prosecution. But in terms, none of that really had any relevance to the venue question in Gibson County, or whether there was venue in Gibson County.
I thought they had found some boots there, like sitting outside on the porch, and they said they thought that was a drop-off point for drugs.
I do not recall that bit of testimony. I might be mistaken. If that testimony was in there, I still don't think it would relate in any way to venue over these two prosecutions. So even if there were some kind of drop-off point at the victim's mother's house, that wouldn't say anything about whether Mr. Graves did anything in Madison County that would merit prosecution for these two offenses.
So can we talk about Young a little bit? The Young case?
Sure.
The Supreme Court case, because obviously the state's relying on that.
Yes.
Pretty heavily. I mean, first-degree murder is not a continuing offense. Do you agree? It's a killing.
I would say that under the reasoning of that case and the way they describe first-degree murder and the element of premeditation is they strongly suggest that it is a continuing offense, because the way they describe the actions of the defendant in that case, what they are describing is a course of conduct between one county and then the county where the victim died. And what they say is, well, it's clear he formed premeditation while, I think it was in Shelby County, even though the victim was not killed until they were in a neighboring county. But the way the Supreme Court explained itself was they said, here is all of the things that the defendant did in Shelby County related to the victim. So I believe it was something to the effect of like a kidnapping or a robbery that kind of became a kidnapping that moved into another county. And so what the Supreme Court was able to do was say, well, it was clear that he formed premeditation there. That is not, we don't have that same course of conduct in this case that would suggest any action on Mr. Graves' part that he's doing any part of this or doing anything that would constitute an element of this, again, very simple offense of just a sale of narcotics.
Yeah, but the state's saying that the mens rea element in this case was established in Madison County when the victim and the defendant met at Anna Parker's house.
Anna Parker's house is in Gibson County. That's the problem.
In Gibson County, I misspoke, I got that backwards, that the defendant decided to sell and deliver drugs while he was at his house in Madison County and then traveled to Gibson County for that purpose. So they're saying the mens rea was established in Madison County. So why are they wrong on that?
Okay, so they are wrong on a couple of fronts. They're wrong first on the facts. I think the argument or the claim that he was at his house, I don't believe there's any indication of that. What the state presented was cell phone records that established that Mr. Graves was in Jackson, I believe he's in downtown Jackson, at 4 o'clock in the morning on July 24th, and he and the victim are exchanging some text messages or that morning and from the prior night. Those text messages, or in those text messages, they're almost exclusively from the victim or the buyer in this case, not from Mr. Graves. Mr. Graves does not say anything concrete from which you could conclude that he was attempting to sell drugs or do anything of that nature. The only thing we get from those text messages is, I'm here in Gibson County, are you coming to see me? And Mr. Graves responding, eventually, I'm outside. But that's the only thing that the state has. They have text messages that they say Mr. Graves sent while he was in Jackson or in Madison County, and that those text messages are sufficient to convey or establish that venue is proper here. But those text messages do not in any way reflect on the offenses that are charged. There's no discussion of amounts, there's no discussion of amount of money, there's no discussion even of type of drug. So what the state is arguing here is that this is a prosecution for the sale of methamphetamine and fentanyl, or methamphetamine and heroin, is that Mr. Graves somehow intended to commit that very specific offense in Madison County, even though he doesn't use any words that would suggest that's what he is intending to do.
Yeah, but circumstantially, when you view that with everything else in the record, that he went to Gibson County and it appears he's found guilty of selling and delivering an offense that seems occurred in that county. I mean, circumstantially, couldn't you say that intent, or at least that knowing awareness was formed in Madison County?
I think what you might be able to say from that is if they had charged conspiracy or they had charged attempt maybe, you could say, well, he took a substantial step perhaps in Madison County that would extend or that would constitute part of an ongoing transaction that ultimately ended up in Gibson County. But they didn't charge that. They just charged that he knowingly sold heroin and methamphetamine to this person and that happened in Gibson County. That there were some possibly preparatory steps that the jury could have said, well, he must have been thinking about this when he started driving to Gibson County. The state has not pointed to a single case where a drug prosecution has been done that way. The only thing they can point to is the Young case where we're dealing with premeditation and a course of conduct that is proven in detail. Whereas here, the only details we have are some vague text messages, most of which are not coming from Mr. Graves at all.
So he was convicted of sale and delivery as to both drugs,
Yes,
I
of
believe.
both heroin and methamphetamine, and then they're merged at sentencing.
Is there a distinction here between the sale and the delivery?
I was thinking about that, and sometimes there is a slight distinction between the two, but here, based on the proof, I don't really see much daylight between the two, because the proof is pretty simply, he entered the house in Gibson County and sold these substances to the victim, in kind of end of story.
Because if you look at the legal, and I think this is the legal definition of deliver or delivery, it means the actual, constructive, or attempted transfer from one person to another of a controlled substance. So, I mean, could the jury find that at some point that the defendant had delivered these drugs because he had left Madison County to go to Gibson County for an attempted transfer?
I think if that is like theoretically possible, and I'm not sure it is, but if it were, if that's like a legally permissible way to consider it, I think factually the state would need considerably more evidence of what Mr. Graves actually did in Madison County, rather than what we have is, we have cell phone records showing that he is in Madison County while the victim is texting him. And for the most part, he's not responding at all. And when he does respond, it's, I'm on my way. That's all we have. So without more than that, it's difficult for me to see how a jury can conclude that he had, when we're talking about attempt, we're talking about a specific intent to deliver these two drugs to Mr. Gray, and they just don't have that with those text
Was
messages.
this charged as an intentional offense? Or just knowing?
It's just under the statute, which is knowingly.
Okay.
Yeah, they did not add anything to it other than that, so it's just the statutory definitions of knowingly is all they had to prove. But again, without more, I don't think they can get there on the facts. And that's again going back to the larger question of can they even get there on the law, which I think they have not been able to point to any case showing that this is a continuing offense where it's even possible to commit one element of this offense in one county and a second and the other element in another county. Even if it is theoretically possible, they need much more proof to get there. And if they're wanting to do this sort of thing, I think they need the legislature to change the statute to make it clear that this is a continuing offense that can be charged this way. Because the legislature can fix this if it is indeed a problem whenever it wants by adding the sort of language that the Supreme Court talked about in Legg that makes an offense continuing, where they're looking at the kidnapping statute and they're saying, well, based on where they're using these words, those words imply an ongoing course of conduct, whereas the word sale does not. And that's the only word we're really saying in this statute that is relevant here.
All right.
And the sale,
You're at your time, Mr. Ridley.
Gotcha.
And you still got your rebuttal time of 3 minutes.
I will then wait for rebuttal for the rest.
Sure.
And ask the court to reverse. Thank you.
Mm-hmm. General, good afternoon. Remind me of your name again?
Ryan Davis.
Ryan Davis. It's good to see you.
Second argument.
Okay, that's why.
Good afternoon, Your Honors. May it please the court. Ryan Davis on behalf of the state. This court should affirm the defendant's convictions because any rational jury could have found by a preponderance of the evidence that venue is proper here in Madison County. So, my friend mentioned that some of the facts were undisputed, but I think as he got into his argument, we've kind of have a dispute about the facts here. And so I just want to give a brief little factual background and then dive into the venue legal analysis. So the defendant was a Madison County drug dealer. His base of operations was a house here in Jackson, 280 Scott Street. And the defendant met Mr. Gray at a club in Gibson County. They became friends, exchanged numbers, and from the text messages in Exhibit 6, it appears that they engaged in repeated drug transactions, at least one of which seems to be here in Madison County. On the evening of July 23rd, 2019, the defendant, Mr. Gray, reaches out to the defendant looking to obtain drugs. And the pair go back and forth over text messages with several calls mixed in. And
This is to the counts that are relevant here. You're giving broad, like a broad overview of the
Yeah,
case,
sure.
I know, but I'm just trying to see when you get to these counts, let me know what I
yes, Your
need-
Honor, this is about the sale and delivery at issue here.
Okay.
Which took place, Mr. Gray died on July 24th, 2019. So
Okay.
the text message that started this off was on the evening, July 23rd, 2019.
Okay.
So they go back and forth, and in these text messages, Mr. Gray provides several potential locations, and he also talks about drugs and dollar amounts. So this is Exhibit 6, and my friend does a really good job of reprinting some of these text messages in his brief, but I would encourage the court to look at all of the text messages at issue. But as far as drug amounts, Mr. Gray says that 450, almost 100 more, do this, I got you, 75 bars and 175 cash on the whole thing, and I'll need a little 30 of that other, right? So that's kind of the nature of this conversation. And eventually, the defendant, while in Madison County, replies, say no more, bet, and I'm about to leave, or something like that. A little later, the defendant then travels up to Gibson County, texts Mr. Gray, I'm outside, and that's where the physical exchange occurs. Mr. Gray then comes back to Madison County and dies. And so
So the physical exchange occurs in Gibson County?
Yes, Your Honor.
And the victim dies in Madison County?
Yes, Your Honor.
The charges are, or charge Madison County?
Yes, Your Honor.
There's nothing pertaining to Gibson County, just so I'm clear?
Correct.
Okay.
Yes, Your Honor. So charged in Madison County. And for venue, what the state needs to show is that at least one element of the offense occurred in Madison County for this case. And so here we get venue based on the defendant's conduct and his mental state. So starting with his conduct, we have a sale and we have a delivery. So a sale is the bargain for offer and acceptance plus a actual constructive or attempted transfer or delivery. Here, the text messages show that Mr. Gray effectively engaged in a bargain for offer and acceptance while he was in Madison County. When he says say no more and bet, he's accepting, or any rational jury could find that he's accepting Mr. Gray's terms and conditions of the sale. And
I'm trying to follow you. I understand that there were comments back and forth with text messages. And so and you're saying that occurred in Madison County?
while the defendant was in Madison County.
And that satisfies the knowing, the mens rea element of sale?
Well, so I haven't gotten to the mens rea yet. I'm still on the
Okay.
conduct elements.
Okay, so you're on the conduct elements?
Yes.
And you're saying that the conduct elements occurred in Madison County?
Yes, Your Honor.
Okay.
We know that the definition of sale is broad, according to this court's opinion in Holston. And so the defendant, he engaged in a bargain. This was a bargain for offer and acceptance while he was in Madison County, and then he commenced the delivery while he was in Madison County. So his conduct elements for both sale and delivery occurred in Madison County. And
Based on the text messages?
the text messages and the cell phone tower location data.
How do you get to a sale under those circumstances? Because you have to have an offer and acceptance and an actual or constructive transfer or delivery. So until he gets to Gibson County, how do you have an actual or constructive transfer?
So we have the beginning of a delivery or what is part of a delivery. when we think of delivery, step outside of the criminal law context. When I order a pizza and the pizza driver is delivering me my pizza, he is delivering the pizza from the store to my apartment until he hands it over. That's a delivery. And so here, when the defendant said, "I'm on my way," that signified that he was leaving Madison County and traveling up to Gibson County. And so that is a delivery. It's a delivery every moment until he hands over the drugs. And so that occurred. He had to go through Madison County. He had to go from Jackson to Trenton. He had to go through Madison County to.
What about the sale, though?
So the sale, we're relying on the definition of sale for that. And here, so we incorporate the definition of delivery as the second part of sale. But then you have the bargain for offer and acceptance, which is the first part of the definition of sale. And that occurred per the text messages in Madison County. And so we think that the defendant's conduct elements occurred in Madison County. If you just break it down into the two-part component of a sale, plus the second part of that is a delivery, that clearly occurred in Madison County.
Has the state ever, charged this way before in drug cases? This is a single count drug offense, right?
Yeah, sure.
I've just never, this is very unusual. What you're arguing is very unusual application of the drug statute, I guess.
Yeah, sure. So there were multiple counts, just to be clear about that. But, I haven't seen a case like this, but I don't think we need a case because we have Rule 18B that says we get venue wherever an element of the offense is committed. And then we have to construe these venue provisions liberally, just based on the history and how they abrogated the common law, and that's per Cagle v. State. And so, while the question is, could any rational jury just view this proof and conclude that part of these offenses occurred in Madison County? That's the essence here. And
Your own witness said none of the offense occurred in Madison County.
I don't know if he said that exactly. He said the physical exchange occurred in Gibson County.
Okay.
And so if you break the conduct elements down into the two-part component of a sale, and then you think about what a delivery actually is, then the conduct elements occurred in Madison County.
So if we agree with you, then the state will be permitted to charge, because you're asking for a broad construction of the drug statute or the interpretation of sale and delivery, right? Mm-hmm. So that means now that the state can potentially charge drug transactions anytime somebody thinks about engaging in a drug transaction in one place and it actually occurs in another place. They can just dispense with, investigating and charging conspiracy.
Your Honor, if we get to the mens rea portion, which is what I take your question to really be driving at, we know from Young that venue is proper where the mens rea is formed. And so that's kind of the limiting principle here. When the defendant, based on these text messages, knows that he is engaged in a bargain for offer and acceptance, and he's getting in his car or a car and traveling up to Trenton, he knows he's engaging in a drug sale and delivery. He's aware of his conduct. And so, so that's part one. Part two is, he's not going from Shelby County to Knox County. He's going to an adjacent county. And so I think that kind of fits within the pattern of the cases in this area. So in Young, the defendant went from Shelby County to Fayette County, an adjacent county.
Young is the first-degree murder / kidnapping?
It was first-degree murder.
Where the
Yes, sir.
defendant took the victim in one county and killed her in another county.
The body was found, and so, yes, Your Honor. And then if you look at Knight, which is the embezzlement case, it was Knox County and Blount County, adjacent counties. And so where the fraudulent intent was evidenced in Blount County and Knox County. So, Your Honor, It
just seems like you're asking us to interpret the drug statute in a very broad way when in reality, the state just made a mistake on their venue, on this venue count, your charge. Well, it just seems like you're doing a lot of gymnastics on this venue issue, when it just seems like they made a mistake in putting Gibson County and not putting Gibson County in the charging instrument.
Your Honor, I don't know if the state made a mistake. I wasn't there. I can't answer for that.
But you're asking us to do something quite unusual.
Well, I'm just asking the court, or we are just asking the court to apply Rule 18B, and whether an element of the offense occurred in Madison County.
Let me ask you about that, your interpretation of Rule 18 as well, too, because you talk about in your brief that it doesn't have to be continuing course of conduct, but in your arguments, it sounds like that's exactly what you're saying was happening, that the bargain for exchange began through these text messages while the defendant was in Madison County, and it continued on until he brought the drugs to Gibson County. So is this a continuing course of conduct offense here, or does it really matter as long as one element occurred in each county?
Your Honor, so it doesn't matter, just up front, as long as one element of the offense occurred in Madison County. But we do think that these sale and delivery, if the court analyzed it under a continuing offense framework, would be continuing offenses.
You're making an alternative argument.
Yes, Your Honor. And really, if you start with delivery is a continuing offense. The concept, like I mentioned earlier, the concept of a delivery is continuing in nature. And so you start with that, and then the definition of sale incorporates the concept of delivery, and the definition of sale is broad per this court. And so they are continuing offenses. But like I said, we don't need to get there. Rule 18B, just applying it, whether an element of the offense occurred in one county, venue is proper in that county.
Is 18, I mean, I hear you, but is it really that clear cut? Because it says if one or more elements of an offense are committed. And when you use the word committed, that kind of makes me think of the actus reus instead of the mens rea. How do you commit unknowingly?
So,
in the context, especially of a sale, you're talking about what the defendant's mental culpability was at the time that the sale took place. I think delivery may be a different argument, but what was the defendant thinking when the sale took place?
So as far as the mental state needed for sale, State v. Gapehart is illustrative, or it's actually right on point. And it's a published case from this court, 2024. But for a sale, the state has to show that the defendant was aware of the nature of the conduct or that his or her conduct involved the sale. So the state we had to show that the defendant knew that his or her conduct involved the sale, right? And part of a sale is a bargain for offer and acceptance. The text messages are evidence. Any rational jury could view these text messages and conclude that the defendant knew he was engaging in a bargain for offer and acceptance, that type of exchange. And once again, this is a low bar. It's preponderance of the evidence. And so could any rational jury view these text messages and find that? Yes. As far as the, mens rea again, I'll push back a little on something my friend said about Young, where he said that Young was a continuing offense case. I don't think that's exactly accurate. Young doesn't cite State v. Legg at all. Young was from 2006. State v. Legg, which is the continuing offense case, was from 1999. And so what Young does is it cites Rule 18B, and that's kind of the hook it uses to get venue in that case. And so really, we get venue based on the conduct, like I mentioned before, or the mental state. And, I know we haven't cited a case that says, that stands for this proposition in a drug sale or delivery context, and I understand the court's hesitation.
Yeah. I'm just not seeing anything or the state argue anything like this really ever.
And I understand.
Yeah.
And I understand the court's hesitation, but we think if we just apply Rule 18B, and what's an element of the offense? Well, you have the conduct and you have the mental state. One of those occurred in Madison County. And any rational jury could have found by preponderance of the evidence that was true.
Very well argued.
Thank you.
Thank you so
We
much.
ask that you affirm.
Mr. Ridley?
Okay, I'll be very quick. The state seems to be arguing, though it's not entirely clear, but it seems to be arguing that this is a continuing offense. When it cites Rule 18B, I think the only thing you can rely on 18B for is that this is a continuous offense.
Where are you getting that, though? Because that's kind of tripping me up a little bit.
The 18B is talking about, well, an element can happen in one county and then an element can happen in another county and you can prosecute in either. That definition to me comes from the definition of continuous offense, which is an offense that by its nature and by the language the legislature used to define the offense contemplates a course of conduct that can happen over multi-counties and multiple jurisdictions.
Yeah, but when you look at, like kidnapping, they were just focusing on one element in kidnapping when they reached that conclusion. It was the removal or confinement.
Correct.
So they're not saying, okay, you got one element happening here, another element happening here. They're like, no, one element, removal or confinement, by its very nature is a continuing offense. As long as the confinement's taking place, that offense is continuing. 18, I don't read to be limited in that way, that it has to be a continuing offense. It's just that one element can happen here, another element can happen here, and venue laws in either jurisdiction.
Okay, to be honest, I had not thought of it in those terms. Probably mostly because of the way it comes up in practice, where the types of offenses that get prosecuted this way are going to be continuing. But I guess even if that is a reading of Rule 18B, it does not change the facts of this specific case, that where the state cannot point to much behavior or act on the part of Mr. Graves that actually took place in Madison County. What the state is describing is a pretty ordinary drug prosecution of he went to somebody's house, allegedly, sold drugs, then he went home. That's the only thing that matters for this offense. And that's a pretty straightforward offense to prosecute in Gibson County.
It is, and it's reaching us in a very weird posture, as you acknowledge that you had this second-degree murder theory.
Which the state could have prosecuted in Gibson County, if it had so chosen. Everything about this case could have been prosecuted in Gibson County. The problem, or
The homicide?
especially the homicide. So the way those cases, or the way that statute is written, is there's the sale of narcotics and then there's a subsequent death. The state can prosecute the murder part in the county where the initial transaction occurred. So if the state had wanted to prosecute all this together, and I understand why they might have wanted to, they could have done that in Gibson County. The problem comes in this case because they chose to prosecute it in Madison County. And despite the state's argument now, which I don't believe that it was in the brief, that these being neighboring counties somehow matters, these are nonetheless two separate jurisdictions with two separate elected DAs, and we have a constitutional provision saying that venue needs to be prosecuted in the county where these things happen. And the state can't point to something that happened in Madison County that is related to the offense they're trying to maintain the conviction for. And again, because of Hutchinson, the remedy here is they can go try this in Gibson County, where it should be, if they want it to be, a simple prosecution based off the way these prosecutions happen every single day in the state. And I think that brings to the larger point of there is no need for this court to engage in the long kind of abstract ideas that the state's wanting the court to engage with, because this court can simply say, you can try again, and you can try again the way you've prosecuted millions of drug prosecutions in the past. Prosecute it where it happened, with those jurors from where it happened, judges from where it happened, and prosecutors and defense attorneys likely from where it happened. There is no need to get into an analogy about how other types of deliveries or Amazon or pizzas are delivered. The court can just focus on, this is how these things are always prosecuted, and if we're going to create or expand the way we conceive of venue in the state of Tennessee, then the state needs to point to something other than its impressions, I suppose, of what the law might become. They need to point out to something more reliable. They need to point to cases where this has happened before, and they can't do that. And I don't think this court should expand the Tennessee's law of venue the way the trial court seems to have done in a case where the facts just don't support it and there is no need to do it when the state has other avenues to get exactly what it wants if it so chooses. But so for those reasons, I believe my time is certainly up. So I ask the court to reverse and remand with instructions. Thank you. Counsel.
Great argument and briefs by both parties. We appreciate that. The matter will be taken under advisement. Call the next case.
State of Tennessee versus